if you've been accused of rape, the police will go through a process. And it's very important from your side to understand that process. By taking the correct legal advice, we can hopefully avoid a prosecution, or if you've been prosecuted already, to avoid a conviction. When the police are first informed of an alleged assault, the attitude now of the police force is very much, yes, we believe the complainant. So if, and it's normally a woman, most of these cases involve females, although a male can be raped, but most of them involve females. So if a female goes to the police station and says, look, I'm the victim of rape, then the attitude of the police is very much, we believe you, let's look for the evidence. And so the attitude there is they're looking and having the interviews with her, getting everything ready to make their case as strong as possible. You, on the other hand, have often got nobody with you. There's no assistance. You may not have legal advice at that stage. You might have a duty solicitor at the police station who then does relatively little with you afterwards, and you're left on your own. What we need to do is to try to look at what this evidence is and how we deal with it. There's generally two forms of defence with a rape allegation. Or perhaps I could say three. I'll mention them briefly to you. The first defence is there was no sexual contact, full stop. It never happened. There was no sexual touch, no sexual penetration, nothing. Full stop, did not happen. The other second offence is, well, yes, there was sexual contact, but it was fully consensual. And that might be that it was a girlfriend, that it was a partner, a wife, or somebody you've known for a while, you've been seeing for a while. So yes, there was sexual contact, but it was fully consensual. So consent is the defence argument. The other is that there was a reasonable, I suppose you could class it as a third defence, reasonable belief in consent. So even if there was no consent as such, but you had a reasonable belief that there was consent, then that's also a defence. So it's very important that we as solicitors, if we're advising you, that we look at what the allegation is, the whole circumstances of the allegation, look at what the evidence is, get the evidence as quickly as possible, deal with any interview carefully to protect your interests, but also start to look at what the defence argument is going to be. Probably in most cases we deal with it's consent or a lack of consent. Most cases, yes, clients will accept, they know the person, they're in a relationship with them, penetration took place, sex took place. The argument is, was there consent or not? She says no, he says yes. That's where it comes down to. Occasionally it might be that there was a reasonable belief in consent, even if there was if she says no consent, if there's a reasonable belief in consent. Because let's face it, I don't think anybody these days gets a signed contract before they sleep with somebody. So it's always up to interpretation. But when these cases, if the cases are dealt with properly and the defence is structured in the right way, I do feel that they are a difficult case for the prosecution to succeed with. Because generally there's no independent witnesses. It's her word, his word. It's just two people. Now, if this goes, as it will go to the Crown Court, to a trial by jury, if it's prosecuted, the jury will be thinking, who do we believe? There's no independent evidence, there's no CCTV, there's no independent witnesses there in most cases. And even if the complainant comes across as credible and believable, and the jury might think, actually, we believe what she's saying. She was upset, she explained it, she said there was no consent, we tend to believe what she's saying. But then they hear from the defendant, and the defendant comes across as credible and believable and maybe gets upset in giving evidence and says, look, I did not do this. This was fully consensual. And the jury is thinking, well, we believe him. He comes across as believable. How do they reach the decision? What is the decision going to be? Well, in my view, it's not guilty. Because to convict somebody of rape, 12 people on a jury, 12 out of 12 people, have to be convinced beyond reasonable doubt, it's a very high standard, beyond reasonable doubt, that my client is guilty of the offence. And that's a high standard to reach. And if they can't be sure, if they think, well, we believe her, but we believe him, they can't convict. In effect, they've got to believe her almost entirely and completely disregard everything my client said. And that's a difficult situation to be in. Even if the judge allows a majority decision, if all the jury can't decide one way or another, the majority decision can't go below 10 people. So the prosecution service has always got to convince 10 people out of 12 that you're guilty of the offence beyond reasonable doubt. The alternative way of looking at it is we need to keep doubt in the minds of 3 jury members. So if 3 people are not sure, you can never be convicted of rape. So dealing with the case properly, dealing with the steps, the evidence, the defence arguments, structuring it in the right way. If it's before charge, we want to try and stop you being charged. There's action we can take, pre-charge engagement with the prosecution. If you've been charged, then there's a whole process to go through, again, to try and stop it reaching a trial. But if it reaches a trial, we need to defend it properly to give you the best chance of success. So please get in touch. More than happy to have a consultation with you. There's no charge for the initial consultation. Discuss your case, and if you do want us to act, we can often do that on a fixed fee to cover all of the costs involved.